In the last class, we have discussed till the section 111 of the TP Act, and today is the last class of the Transfer of the Property Act, in which we are going to complete the session of the concept of the lessor and the lessee, and this is the last thing we have left out to discuss. Okay, so till we have discussed section 111, and we have discussed how the forfeiture of the property is been done, how the like how the lease comes to an end, what are the basic duties of the lessor, what are the basic duties of the lessee, and how the lease can be determined, how the lease can be created, and most importantly how the lease can be terminated. What are the basic criteria, what are the basic terms and conditions which can terminate the lease, that we have already discussed under section 111. Okay. So when coming to the part of section 112, this is where we are going to discuss about the waiver of the forfeiture. Okay. So under this section 111 sub subclause G, we have discussed about the forfeiture. Okay. And we have discussed that the lease can be terminated by the forfeiture of the lease. Okay. So under the forfeiture clause G, what we have discussed, the lessor can end the lease if the lessee breaks a clear condition of the lease. The first thing, if the lessee claims ownership of the property for themselves or claims a third party owns it. The third point was the lessee becomes insolvent and the lease allows the lessor to re-enter if this happens. So these are the major conditions we have discussed under clause G of section 111, under which it has been discussed that the lessor, the person who is the lessor, who is giving the lease, okay, the person is who is giving the lease is called the lessor. The lessor can end the lease. If the lessor wants, he can terminate or he can end the lease if these following condition is being satisfied. So what are those conditions? The first point is the lessee breaks a clear condition of the lease. That means the lessee breaks a clear condition of the lease. There is a specific terms and conditions of the lease, and these terms and condition has been broken by the lessee. The person who has taken the lease is called the lessee, and the person to whom by whom the lease has been given is called the lessor, right? So when the lessee breaks the condition of the lease, okay, this is the primary condition in which the lessor can terminate or end the lease. The first thing. The second thing, the lessee claims ownership of the property for themselves or claims a third party who owns it. When the lessee claims owner claims the ownership of the property for themselves, the lessee knows that the property belongs to the lessor, and the lessee knows that the lessor is the original owner of the property. But even after knowing that, the lessee is claiming the ownership on the property for themselves, and he claims a third party who owns it. Okay, so this can be a condition to terminate the lease by the lessor. So here, under these circumstances, the lessor can end the lease if the primary condition, the lessee breaks a clear condition of the lease. The second thing, the lessee claims ownership on the property for themselves or claims a third party who owns it. Whether the lessor is the original owner, but the lessee is demanding himself or herself to be the owner of the property, or he is demanding demanding someone else who is not the actual owner, but according to the lessee, that person or that third party is the owner of the property. And the third point, the last important point, the lessee becomes insolvent and the lease allows the lessor to re-enter if this happens. That means if the lessee he becomes insolvent in nature and the lease allows the lessor to re-enter if this happens. That means the lessee becomes insolvent in nature and the terms and conditions of the lease. Okay, it allows the lessor to re-enter if this happens. Okay, even after the lessee becomes insolvent in nature, even after the lessee is unable to pay the specific amount to the lessor, then it is up to the lessor. It is up to the lessor to decide that whether the lease allows the lessor to re-enter if this happens. That means if the conditions support afterwards, it is up to the lessor to allow the lessee again for that specific terms and conditions of the contract. Okay? But when the lessee becomes insolvent for that specific time period, the contract becomes insolvent. The contract closes, right? But when it is up to the lessor that he can decide afterwards that if he wants, he can permit the lessee to be the lessee again when the insolvency of the lessee is been completed or is no more. Okay. So when we are talking about the forfeiture of the property, forfeiture of the lease, under that we have discussed the lessor can end the lease if the first thing the lessee breaks a clear condition in the lease which violates the terms and conditions of the lease. The first thing. The second thing, the lessee claims ownership of the property for themselves or claims a third party to own it. Okay, this is the second point. And the third point is the lessee becomes insolvent and the lease allows the lessor to re enter if this happens. Okay, and according to the point number two, we have discussed the ownership on the property if it has been claimed by somebody else. Okay, so it's called the forfeiture. Okay, so when there is the forfeiture of the lease, a forfeiture under section 111 subclause G can be cancelled if the lessor accepts the rent that became due after the forfeiture. And the second point is the lessor takes any action showing an intention to continue the lease. Okay. So let's understand this. When we're talking about the forfeiture under section 111 subclause G, it can be cancelled. Under what circumstances? The first point is if the lessor accepts the rent that became due after the forfeiture of the property. That means under the forfeiture we discussed how the property is being forfeited, how the property like when there is the lease, how the lease can be terminated, that we have discussed. And under the forfeiture of the property we have discussed that the forfeiture can be cancelled. The forfeiture of the property can be cancelled. The closure of the property can be cancelled if the lessor accepts the rent that became due after the forfeiture. Forfeiture means denial of the lease. For example, you are staying at my place from a long time, from 3 to 4 years. I am coming to your place and I am telling you your property has been forfeited due to the above mentioned reasons. Just like I told you the reasons. For example, you have taken my home as the lease. You are staying at my home, but you are misusing my home. I have given my home for the purpose of living only, but you are using it for the commercial purpose, which is not a bad option for us. But when when it comes about the breaking of the lease conditions, when it comes about the breaking of the terms and conditions of the lease, then as the lessor, I have my right to terminate the contract. I have my right to terminate the lease because I have signed you something. I have done the contract according to certain terms and conditions. So you have to follow it up. And if you are not following it up, then I have right to terminate the contract or terminate the agreement with you. Okay. So if the lessee breaks the condition of the lease, the second point, if the lessee owns the claims the ownership of the property for themselves or claims a third party to own it. And the third one, the lessee becomes insolvent and uh, the lease allows the lessor to re-enter if this happen. Okay. So when we are talking about the denial of the forfeiture, okay, for example, the property has been forfeited. Forfeiture means denial to continue the lease. For example, you are staying at my place as the lease and you are enjoying my property as the lease, you as a lessee, right? So when I want to cancel the forfeiture of the property, that means I have already denied you that you cannot continue the ownership or you cannot continue this contract with me and you have to terminate this contract or you have to forfeiture the property. Okay. So the forfeiture under section 111 clause G can be cancelled for what? The lessor accepts the rent that become due after the forfeiture. For example, you have given me the notice for the forfeiture of the property before the duration of the 1 month. Okay. But even after getting the notice, I used to stay in the house. I did not leave the house and I continued to stay in the house. Okay. So when I stayed at the home or I continued to stay at that specific house for the longer duration, okay, after that, uh, I offered you the amount of the rent, okay, the rent money that has been due. You have given me notice to quit the home in the month of July. But even after getting the notice to quit the month, I did not leave the home. Still, I continued to stay there. And in the month of August, I am giving you the house rent itself. So, you are accepting the rent even after the order of the forfeiture. That means when it has been the order for the forfeiture of the property, the thing has not been done accordingly. Okay. And when it is it is after the due period. Forfeiture means the denial, the negotiation to continue the lease. मतलब मैं आपको बोलती हूँ कि आप अगर मेरे जमीन को लीज पे लिए हो, आप अगर मेरे घर को लीज पे लिए हो तो आपको छोड़ना पड़ेगा. You have to leave the enjoyment of my property. This is called the forfeiture of the property. And we are talking about the waiver of the forfeiture. That means मैंने आपको जो बोला था तो रिगार्डिंग द फॉरफीचर ऑफ द प्रॉपर्टी कि आपको ये चीज नहीं करना है. यू कैन नॉट एंजॉय द लीज, यू कैन नॉट एंजॉय माई प्रॉपर्टी, but then I am giving you permission. No, you can enjoy the property, you can enjoy the lease. Okay, that is called the denial or the waiver of the forfeiture. Forfeiture means to deny something, to negotiate something. Waiver of forfeiture means to deny the denial. That means to accept something even if it had been denied, it had been negotiated. The forfeiture under section 111 clause G can be cancelled if the lessor accepts the rent after become due become for the forfeiture. That means if the rent it has become due after the forfeiture. For example, the forfeiture of the property that has been done in the month of July, but we are coming here in the month of August. But the person who was staying at our home as the tenant, or who has taken the home as the lease, he is coming and offering the rent amount, and I am accepting the rent. So here I am doing the waiver of the forfeiture rent. The second point, the lessor takes any action showing an intention to continue the lease. That means it is the lessor. He is showing any kind of the action or intention to continue the lease. For example, after getting the notice of the forfeiture, I am calling the lessor. I am telling him that, see sir, these are the problems over here, and I do not want to blank the house at this current moment. I don't have sufficient money for that. So here the lessor takes any action showing the intention to continue the lease. Okay. So here, when we are talking about the waiver of the forfeiture, it can be done in two specific ways. First point, the lessor accepts the rent that become due after the forfeiture. The rent amount was due. It was already on due after the forfeiture, which the uh, uh, lessor has the idea about this. Okay. So when it is the notice of the forfeiture has been completed, it is about to be forfeiture of the property, but even after that, the person who is the lessor accepting the rent from the lessee, okay, accepting the money from the lessee after the forfeiture period. The forfeiture notice has been given in the month of July, but I am accepting the rent as the tenant on the month of July and August. Okay. So here it is clearly seen that the lessor accepts the rent, but that became due after the forfeiture. Okay. That means the lessor takes any action showing an intention to continue the lease. The lessor is showing his own interest. He is showing any kind of the action. Either he is accepting the money, or either he is extending the terms and conditions of the agreement. He is just giving any kind of the hint, any kind of the sign, any kind of the interest that is proving that he is interest to continue the lease. Okay. This is explained under section 111. 112. So 13 speaks about waiver of notice to quit. A notice are given under section 111H can be cancelled if the person who gave the notice shows by their action or they wish to continue the lease. Okay. Under this, it is spoken that when there is the notice given under section 11G can be cancelled, it can be negotiated, it can be denied if the person who gave the notice shows by their actions and they wish to continue the lease. Okay. So under section 111H, we have discussed about the given notice regarding the notice to quit. Okay. The notice to quit was supposed to be given, but it can be cancelled, it can be negotiated, it can be denied if the person who gave the notice shows by their action that they wish to continue the lease. Okay, what does it mean? It means that when the person who gave the notice with or without consent shows his intention to continue the lease, वो अपना intention दिखाता है कि हाँ मैं हूँ, must be who has given the notice, that means the lessor. if the lessor shows the interest to continue with the deal. Okay, even after uh, mm, giving the notice to quit, if the person is showing through their action with or without consent that he wants to continue the lease or anything, he is giving his proof that then in the situation, this waiver of notice to quit under section 113 does not work. Okay. Then comes section 114. Okay. So when we are talking about next section 114, it speaks about the relief against forfeiture for non-payment of the rent. Okay, that means what are the relief against the forfeiture? When there is the non-payment of the rent. Okay. So when under section 114 it is spoken that in these ends, due to the non-payment of the rent and the um, non-payment of the rent and the lessor sues the lessee. Okay. When the lessor sues the lessee, the court can allow the lessee to continue the lease if the lessee pays or promises to pay the rent, interest or legal interest within 15 of the days of the hearing. Then when it comes about, and secondly, if this happens, the lease continues as if no forfeiture occurred. Okay. So understanding this section 114 is quite easy. Let me make it clear. The first thing it exactly spoke about, that if the lease ends due to the non-payment of the rent and the lessor in the lessee, the first thing, and the lease ends due to non-payment of the rent. You know, when I am taking something as lease, okay, I have to do the payment on a certain way with a specified time duration, right? So if it happens that the rent is totally unpaid, there is the non-payment of the rent, and the lessor is suing the lessee, then the court can allow the lessee to continue the lease if the lessee pays or promises to pay the rent, interest or legal cost within 15 days of the hearing. And the second point, if this happens, the lease continues as if no forfeiture occurred. Okay. So moreover, under section 114 this is spoken that if the lease ends due to non-payment, अगर पैसे ना देने के वजह से लीज खत्म हो जाता है, लीज टर्मिनेट हो जाता है, and lessor sues the lessee. For example, लीज का जो मतलब नॉन पेमेंट का जो पेमेंट का था वो 5,000 रुपया था. There is the amount of the 5,000 of the rupees. And the lessor क्या करता है? Sues the lessee. Lessor lessee को sue करता है. And most importantly, when the lessor sues the lessee for the extra payment or for the to pay the amount which has not been paid before, the court can allow the lessee to continue the lease. In that specific circumstances, if the court wants, the court may allow the lessee to continue the lease. Okay, what are those conditions? The first thing is the lessee pays or promises to make the art, interest and legal cost within 15 days of the hearing. And the second point, if this happens, then the lease continues as if no forfeiture occurred. Okay, so this is explained under section 114, under which we discussed where the rent has not been paid. Okay. When the forfeiture for the non-payment of rent is there, then if the lease ends due to non-payment of it, अगर non-payment की वजह से lease खत्म हो जाता है, and the lessor sues the lessee, lessor क्या करता है, lessee को जो है ना वो sue करता है. Okay, then the court can allow the lessee to continue. In these circumstances, yes, the lessee can allow the lessor can allow the lessee to continue, okay, to pay the rent, interest, and legal cost within 15 days of the hearing. Okay. Then comes, if this happens, the lease continue if no forfeiture occurred. If there is no forfeiture of the property, if the property is not being terminated, if the lease terms and conditions are not being terminated, then the lease will continue as before. The lease will continue according to the previous terms and conditions that has been decided before. Okay. So here, under section 114, we have understood that when there is the non-payment of the goods, when there is the non-payment of the lease, the specific lease can be stopped from being forfeited, can continue if the lessee, the person who has taken the property or taken the goods, promises or pays back. Either वो पेमेंट कर देता है, नहीं तो प्रॉमिस करता है. अदर पर्सन promises to pay the rent, interest or the legal cost within 15 days of the hearing. 15 दिन के अंदर हो गया, right? And we have discussed that either the lessee pays the rent, lessee जो है either वो rent pay कर देता है, or else he or she promises, वो प्रॉमिस करता है, कमिटमेंट देता है, वादा करता है कि हाँ ठीक है, मैं ये प्रॉमिस कर रहा हूँ या ये प्रॉमिस कर रही हूँ, मैं 15 दिन के अंदर ये जो भी इसी का रेंट है, इंटरेस्ट है, लीगल कॉस्ट है, सारा का सारा मैं चुका दूंगी. Either the lessee, the person who has taken the rent, he is doing something like he is paying the specific cost, or he is promising to pay the cost, pay the amount, rent, interest within 15 days of the hearing. Hearing का 15 दिन के अंदर ये हो जाना चाहिए. Okay. And the second point, if this happens, अगर ये होता है, then the lease continues as if no forfeiture occurred. Okay, done. So when we are talking about this under section 114, we have discussed that the rent, interest or the legal cost must be paid or promised to be paid within the duration of 15 days. And the second point we have discussed that if this happens, then the lease continues. The lease is going on. It continues for the longer period, and there is no forfeiture. The lease such a way like no forfeiture. Comes section 114A. Okay. Under this, it is explained that okay, under 114A, it speaks about the relief against forfeiture for other regions. Okay, that is explained under section 114A. Okay, so when we are talking about the relief against forfeiture for the other regions, okay, then the lease is terminated by any position other than the non-payment of the rent. Okay, the first thing. And second thing we discussed, it will be allowed as if and it can be corrected. 14 clause A, for any reason other than the non-payment of the rent, lessor or must give a written notice, specifically the branch. And the second point is allow the allow and the second point is allow the lessee time to correct the branch and if it can be corrected. Okay. So this is explained under section 114. What are the things has been disclosed over here? First point is if the lease is terminated for any reason other than non-payment of the rent. Non-payment of the rent का वजह को छोड़ के पेमेंट ना देने के वजह से लीज टर्मिनेट हो गया, ये रीजन को छोड़ के अगर कोई भी रीजन के वजह से ये जो लीज है टर्मिनेट हो रहा है, देन द लेसर वो क्या करेगा? मस्ट गिव ए रिटन नोटिस टू द लेसी स्पेसिफाइंग द ब्रीच. वो क्या करेगा? पहला वो लेसी को एक रिटन नोटिस स्पेसिफाई करेगा. ओके, स्पेसिफाइंग द ब्रीच. ओके, एंड द सेकेंड थिंग इज allow the lessee time to correct the breach if it can be corrected. If there is any kind of the breach in the terms and conditions, as we have discussed, if there is any kind of the breach in the terms and conditions, then the lessor has the right to terminate the deed. Then if the lessor wants, then he can allow the lessee, he can give permission the lessee to correct the breach, to correct the mistake and to continue the lease. Or he can give a specific notice to the lessee specifying the breach. He can identify that yes, you are the lessee, you have done this breach and that might lead to the forfeiture of the property. So if you want to continue with the lease, kindly rectify this, kindly correct this breach and you are allowed to continue the breach. So this is explained under section 114A, in which we have discussed that if there is any kind of the breach or any kind of the breach is happening over there, then in that specific circumstances, the lessor has the right to continue with the lease even if there is a breach from the lessee, there is a mismanagement or violation in the terms and conditions on behalf of the lessee. Okay, and when the lease is terminated for any reason, for any reason other than the non payment, अगर नॉन पेमेंट को छोड़ के बाकी कोई भी रीजन है, फॉर एग्जाम्पल just like the reasonable, if there is any kind of the violation of the terms and conditions, okay, or any other reason, so in that specific circumstances, this is the right of the lessor to provide a notice regarding the breach and to suggest the lessee to rectify, to correct the breach and allow the lessee for a specific time period to rectify the breach and it can be corrected. Okay. And next, if the lessee fails to correct the breach in the reasonable time, the lease ends. This section does not apply if the breach involves such transferring, subletting, parting. Okay. So, even after that, if the lessee is unable to correct the breach in a reasonable time, यहाँ पे लेसी जो है ना, वो एक रीजनेबल टाइम के अंदर ये जो ब्रीच है उसको रेक्टिफाई करने के लिए कैपेबल नहीं है, दैट मीन्स द लेसी इज नॉट कैपेबल टू टर्मिनेट द ब्रीच विद इन द स्पेसिफाइड टाइम पीरियड, even after the notice to rectify the breach, even after the notice to rectify the mistake, still the lessee has not taken any kind of the step and he did not rectify the mistake. So here, in that specific circumstances, the breach can lead to ending of the or the termination of the lease. Okay. So this section, okay, does not apply the breach which involves the transferring, subletting, or possession of the property. Like this section is not applicable when there is the transferring of the property, subletting of the property, or parting the possession of the property. In that specific circumstances, this section is not applicable at all. Okay. Then comes section 115. Okay. It speaks about the effect of the surrender and forfeiture under the leases. Okay. Let's read out section 115 once. According to section 115, the surrender, express or implied, of a lease of immovable property does not prejudice an under lease of the property or any part thereof previously granted by the lessee on terms and conditions substantially the same, except as regards the amount of the rent as those of the original lease, but unless the surrender is made for the purpose of obtaining a new lease, the rent payable by and the contracts binding on the under lessee shall be respectively payable to enforceable by the lessor. The forfeiture of such a lease annuls all such under leases except where such forfeiture has been procured by the lessor in fraud of the under lessees or relief against the forfeiture is granted under section 114. So, this is under section 115. It speaks that on the surrender, effect of the surrender and the forfeiture on under lessees. Okay. Under that, we have discussed or we are going to discuss that if the original lessee is given up or surrender, then the under leases are not affected to get a new lease. And the second point, when there is the forfeiture or the lease is forfeited, terminated, then in that circumstances, all the under leases are also cancelled, terminated, except the lessor fraudulently causes the forfeiture to harm the under leases. The first point. And the second point, the court provides the relief under section 140. So, this section 115 we are going to discuss in details in the next class. And we are going to complete this portion of the transfer of the property act as well. This is all for today, guys. We can wrap the class here. Thank you. Bye bye. Take care.